Now I am going to dictate a legal passage based on latest Supreme Court judgment at the rate of 120 words per minute. Let's start. The learned counsel appearing for the state submitted that an offence under section 13 within bracket 1 within bracket E punishable under section 13 within bracket 2 of the PC Act would be abated by a non-public servant, and in such eventuality the only mode of prosecution qua that offender is only through the trial as envisaged under the provisions of the PC Act. It is paradoxical that to drive home the rival stance on the framing of charge under section 109 IPC, both the parties are relying on the decision of this court in PN and another versus state 1, while the appellant relies on the same to support the contention that the offence under section 13 within bracket 1 within bracket small e of the PC Act could be abated by a non-public servant, and the only mode of prosecuting such an offender is through trial as envisaged in the PC Act. The respondent would rely on the very self-same decision to contend that merely because some of the disproportionate assets stand in the name of non-public servant without any element of abatement, the couple would not be asked to face the trial along with the public servant on the ground of their relationship. In short, going by the respondent, there is no material to support the charge under section 109 for abating the husband within bracket 1999. 6 SCC 599 1999 INSC 314 Criminal Appeal number 3175 of 2024, Sri Anil Kumar Shetty to commit the aforesaid offence under the PC Act para. It is contended by the learned counsel for the appellant that though the respondent claimed that she was in an income tax assessee and had filed tax returns, she did not furnish the tax return receipts, and despite earnest efforts, they would not be found in the IT department. It is the further submission of the appellant that having found grounds to proceed against the respondent and a prima facie case made out against her and her husband, the trial court framed charges against the respondent as mentioned above. The order impugnated 05/03/2016 of the trial court rejecting the petition of the respondent herein for discharge filed under section 239 CRPC would reveal that the court virtually considered only the question whether the final report filed in crime number 56 of 2009 can be said to be groundless. It is further submitted that a scanning of the said order dated 05/03/2016 would also reveal that the said question was considered within the scope of section 239 CRPC by the trial court, and it is upon finding that the essential ingredients of the offence for which the respondent is sought to be charged were satisfied, and they are sufficient to form a prima facie case. The said application was rejected by the High Court, and the criminal appeal number 3175 of 2024 respondent was called upon to answer the charge and later framed the charge as mentioned above. Para. Per contra, the learned counsel appearing for the respondent would contend that the High Court has rightfully considered the question whether the trial court was correct in calling upon the respondent herein to answer the charge later and to frame the charge after declining to discharge the respondent herein under section 239 CRPC. It is the further submission that the High Court has rightly held that the investigating officer had failed to prove that the respondent had no source of income in that regard. The counsel for the respondent drew our attention to paragraph number 6 of the impugned judgment, where under the High Court observed and held thus: it is established principle of criminal jurisprudence that the burden always lies on the prosecution to prove all ingredients of the offense charged, and the burden never shifts on the accused to disprove the charge framed against him. Stop. Thank you.